we have seen who is a stockbroker. Stockbroker is an intermediary between the client and the exchange. Now, subbroker is a intermediary between this stockbroker and the client. So, this subbroker who wants to provide service to the stockbroker, first he has to enter into an agreement with the stockbroker. Once they agree upon, as per the general agreements of both the parties, they have to enter into a formal agreement, they have to inform the exchanges, they have to inform the SEBI, they have to take the necessary permissions, and the necessary permissions are issued based on certain criteria by the exchange and by the SEBI itself. So, once this subbroker is registered with SEBI and exchange, he can start supporting the stockbroker. So, stockbroker is an agent of the exchange and subbroker is the agent of the stockbroker. Let us try to see the details between how subbroker can become an agent of stockbroker and what are the ways of becoming a subbroker. Subbroker is an important intermediary between stockbroker and the client in the capital market segment. The trading members of the exchange may appoint subbrokers to act as agents of the concerned trading member for assisting the investors in buying and selling or dealing in securities. The subbrokers are affiliated to the trading members and are required to be registered with SEBI. Please understand, subbroker has to be registered with SEBI, whereas an authorized person is not necessary to be registered with SEBI. A subbroker is allowed to be associated with only one trading member of the exchange. He cannot be a subbroker to so many trading members within the exchange. So, he can become subbroker of one particular stockbroker of this particular exchange only. Trading members desirous of appointing subbrokers are required to submit following documents to the membership department of the exchange. As stockbroker gets registered to the exchange through membership recommendation committee, even the subbroker also has to submit the necessary documents to the membership department of the exchange for seeking the permission and registrations for carrying out the business. What are the documents? A copy of subbroker-broker agreement, duly certified by the trading member, that is the stockbroker. Application form for registration as a subbroker with Securities and Exchange Board of India in Form B. 3. Recommendation letter to be given by the trading member with whom the subbroker is affiliated in Form C. So, these 3 documents he has to submit to the Department of Exchange for the purpose of certification. The trading member has to ensure settlement of all deals entered into by a trading member, even if the deals may have originated from its stockbroker. All the transactions of the trading member, even they are carried out through the subbroker, will be considered as if those are transactions belonging to the trading member himself. The subbroker will be required to adhere to NSE's Know Your Client's requirements. The important documents relating to dealing through a subbroker are given below. Individual client registration application form, non-individual client registration application form, and subbroker client agreement form have to be applied for the purpose of registrations. Eligibility. Who else can become the subbroker of a stockbroker? What are the eligibility criteria for a person to become a subbroker? A subbroker may be an individual, a partnership firm, or a corporate. Any of these 3 constituents can become the sub-broker of a stockbroker. In case of corporate or partnership firm, the directors of the corporate or the partners of the partnership firm, and in the case of an individual sub-broker, applicant should comply with the following requirements. If we want to become the sub-broker, these necessities have to be adhered to. First of all, they should not be less than 21 years of age. So that means if it is a corporate who is applying for a sub-brokership, that particular director in that particular corporate or a partner of a partnership firm or an individual in the case of an individual category should not be having an age less than 21 years. Second, they should not have been convicted of any offense involving fraud or dishonesty. They should have either passed 12th standard equivalent examination from an institution recognized by the government, or he can also clear 10th standard, but he needs to have 2 years of work experience in the securities market. If he has got 12th standard clearance of the examination, then no need for 2 years examination, but if he standard is only 10th cleared, then he needs to have 2 years of experience in the securities market. The fourth point, they should not have been debarred by SEBI. If he is a person who has been debarred earlier by SEBI, he cannot apply for sub-brokership. So these are the 4 categories. He should not be debarred by SEBI, he should be not less than 21 years, he should be more than 21 years of age. Third point is, he should not be convicted earlier for any fraud, and fourth point is, he should have cleared 12th standard. In case he clears only 10th standard, he needs to have 2 years of experience. Now what is the process of registration? Once the eligibility is satisfied for becoming the sub-brokership, then how the registration will take place? No sub-broker is allowed to buy, sell or deal in securities unless he or she holds a certificate of registration granted by SEBI. So only after SEBI certification or registration he is allowed to buy and sell securities. Sub-brokers are required to obtain certificate of registration from SEBI in accordance with SEBI Stockbroker Sub-broker Rules and Regulation 1992, without which they are not permitted to buy, sell or deal in securities. Now, based on the rules and regulations provided by SEBI Stockbroker and Sub-broker Rules of 1992, SEBI may grant a certificate to this stockbroker, sub-broker, subject to the conditions that he should pay the fees in the prescribed manner. This is the first point. Second point, he should take adequate steps for redress of grievances of the investors within 1 month from the date of receipt of the complaint, and keep SEBI informed about the number, nature and other particulars of the complaints received. The third point, in case of any change in the status and constitution of this particular sub-broker, he should obtain prior permission from SEBI to continue to buy, sell or deal in securities in any stock exchange. That is, a person who has become a sub-broker based on individual status cannot convert himself into partnership status. He has to take prior permission with SEBI for the change in constitution of his particular situation. Then only he can continue to buy, sell or deal in the securities. The fourth point, he should be authorized in writing by the main stockbroker, being a member of a stock exchange, for affiliating himself in buying, selling or dealing in securities. So he needs to have a proper recommendation from the main stockbroker to become a sub-broker. The applicant sub-broker should submit this required documents to the stock exchange with the recommendation of a trading member. that is the stockbroker. After verifying the documents, the stock exchange may forward these documents of the applicant to SEBI for registration purpose. A sub-broker can trade in that capacity after getting himself registered with SEBI. The exchange may not forward the application of the sub-broker to SEBI for registration if the applicant dealt with fake, forged, stolen, counterfeit, etc. shares and securities in the market. This membership committee of the exchange will check the credibility of the application, and if they are satisfied so, they can forward for the purpose of SEBI registration. In case they are not comfortable with the applications provided by the sub-broker, they may not forward it to SEBI for the purpose of registration. Cancellation of registration. In case a trading member sub-broker intends to cancel the registration as a sub-broker, the sub-broker is required to submit original SEBI registration certificate through their affiliated trading member. While applying for cancellation of registration, the affiliated trading member needs to give a public notification to this effect. So if the trading member wants to cancel his sub-broker, or the sub-broker himself wants to cancel his registration, then they have to send the application through this main trading member to SEBI for the purpose of cancellation of the membership, that is the sub-broker membership. And the main trading member has to issue a public notification to this effect that he intends to cancel the registration of sub-broker. Now, this is all about sub-broker registrations and cancellations and eligibility to become a sub-broker. We have seen all the various aspects about sub-broker till now. Now, broker-client registrations procedures, we will try to look into it. Broker-clients relations. We will discuss about these things now. First of all, the client registration documents. The trading member is required to enter into an agreement in the specified format provided by the NSE with the client before accepting orders on behalf of the client. The agreement is executed on a non-judicial paper of adequate value, duly signed by both the parties on all the pages. That is, the client and the stockbroker both have to sign this particular agreement, which is given in a prescribed format by the exchange. Copy of this agreement has to be kept with the trading member permanently, that is the stockbroker. The agreement should contain all clauses mentioned in uniform documentary requirement. Stockbroker may incorporate any other additional clauses in these documents provided these are not in conflict with the clauses in the model document, and also rules, regulations, articles, bylaws, circulars, directives and guidelines issued by NSE or SEBI. There should be segregation of mandatory and voluntary documents clauses pertaining to client registration in a separate docket. In case of internet trading, in addition to the clauses mentioned in this uniform documentary requirement, the client has to mention clauses pertaining to internet trading. Under KYC norms, that is, know your client norms, the trading member should seek information such as investor risk profile, financial profile, investor identification details, address details, income, PAN number, employment, age, investments experience, trading preference. All these details have to be collected by the trading member from the client in know your client form. The trading member has to obtain recent passport size photograph of the client, whether it is a director of a company or an individual promoters holding 5% or more, either directly or indirectly in the shareholding of the company, and of persons authorized to deal in securities, and each of the clients in case of individuals. The trading member should also take proof of identification and address of such clients. In-person verification should be done by the trading member staff. He has to take the name, signature of the person doing the in-person verification together with the stamp of the trading member should be there on the KYC norms. So the authorized person in broker office, he has to do in-person verification of the details provided by the client, and he has to put his name, signature and the stamp of the trading member on this KYC form along with the client registration agreement. Under member constituent agreement, popularly known as MCA, trading members are required to make constituent clients aware of these things: trading segment to which trading member is admitted, particulars of SEBI registration number, the precise nature of the trading member's liability for business to be conducted, the basic risks involved in trading on the exchange, equity and various other instruments, including any limitations on the liability and the capacity in which the trading member acts. In order to assess the risk involved in trading, trading member is required to issue risk disclosure document in such format as may be prescribed by the exchange from time to time, and should obtain the same from his constituents duly signed. So this is a very important document. Apart from registrations, know your client forms, this is a risk disclosure document which gives clarity that the client is aware about all the aspects about trading, the risks involved about trading, everything will be clear, and the client has to sign this document also. A stockbroker should not deal knowingly, directly, indirectly with a client who defaults to another stockbroker. There is no limit on the number of clients a trading member can appoint. Copy of the client registration documents is required to be sent to the clients. Trading member must ensure periodic review of client's financial information and client database. So he has to keep track of the changes and the financial status of all his clients, and he should not involve with clients who have defaulted or misled the other stockbrokers. Now, unique client code. This is a very unique code. This code is given to the clients by the trading members. SEBI has made it mandatory for all trading members and brokers to use unique client codes for all their clients. Brokers are required to collect and maintain permanent account number allotted by Income Tax Department for all their clients. Brokers should verify documents with respect to the unique code and retain a copy of that particular document. They are also required to provide PAN and unique client code of their clients to the stock exchanges, clearing corporations, and these details have to be updated before placing orders for the clients. So these details, not only the broker has to collect from the client, these details also have to be informed to the exchange and the clearing corporation, because tomorrow clearing and settlement cannot be done and exchange cannot identify the authenticity of the client who is placing the orders at the exchange. The stock exchanges are also required to maintain a database of the client's details submitted by these brokers. Now, the important point about margins from the clients. So margins are the amounts which the clients have to maintain when they are placing orders and buying or selling of securities. Members should have a prudent system of risk management to protect themselves from client defaults. So if a client is defaulting, the members, the trading members, the brokers can face a lot of issues. So they have to have a proper risk management system to ensure any default doesn't occur with respect to the client's mistrades or mistransactions. Margins are an important element of such a system. The policy of risk management addressing the margin requirement should be well documented and be made accessible to the clients and to the exchanges. In capital market segment, the quantum of these margins, the form and mode of the collection are left to the discretion of the members. The margin so collected is kept separately in the client bank account, in the client beneficiary account. The margin so collected is kept there, and in case a default takes place, they are utilized for making payment to the clearing corporation for margin and settlement with respect to that client. So all the necessary margins are decided by the trading member with respect to the client. Those are informed to everybody, and those margins are kept properly in the beneficiary account, and in case of any sort of a margin issue arises, this particular margin which is kept in the beneficiary account will be paid to the clearing corporation by the trading member on behalf of the clients.